Today, I am thrilled to introduce Samantha Dennis, 3L, who successfully prepared a brief in AC versus McKee. Now, you may see some references to this case as AC versus Raimondo, and that's because Gina Raimondo was the governor of Rhode Island at the time the case was filed. She's now the Secretary of Commerce in the Biden administration, and so her successor is Daniel J. McKee. And so we now refer to the case, and all documentation that the court is now refers to the case as AC, who is a minor. So that's why we use the initials, versus Daniel J. McKee. And this case is at the United States Court of Appeals for the First Circuit. The case is centered on an issue that I think is important to many people today, including parents and maybe students as well. Is there a federal right to education? Now, before Sam gets started on her formal presentation about the case and the issues and the strategic importance of her brief, I want to recognize a few folks who helped the Amicus Project succeed in this filing. First, I see Erica Knoll here among us. I'd like to give a shout out to Erica. She's an undergrad at the University of Southern California, and she's the student who first brought this case to my attention. She did this as part of the Amicus Project USC Writing Fellows Program. So students in this program identify cases for the Amicus Project under the direction of their legal advocacy professor, Antonio Alifano. And I happen to know Antonio is here somewhere as well. So, Erica, you can say hi, and that way, if you're on speaker mode, they can actually see you for a brief second. You can say hi.
Hello, I'm Erica.
Thank you for bringing the case to my attention. And Professor Alifano, you can also, if you're able, just give a brief shout out and say hello.
Hello, everyone. It's good to see you.
Thank you, Antonio. This is a project that is sort of a partnership that's been going on for many years, and we once a semester, we basically, the students in Professor Alifano's class present on cases for consideration by the Amicus Project, and that's precisely what happened here. Erica discovered this case, was very much interested in it, and brought it to my attention. And I then brought it to Dean Waterstone's attention, knowing that this is the subject matter of this case is within her interest and expertise. And then Dean Waterstone and I brought in Sam Dennis to take the oars on preparing the brief. And Professor Alifano has advised me that there may be a number of current and former writing fellows joining us today. And I just want to say that I'm grateful for all the work that these undergraduate students have done for the Amicus Project over the last several years. Mike Bourbeau is a Southwestern alum who practices in Massachusetts. And he graciously walked me through the process of securing admission to the First Circuit. This is the Amicus Project's First Circuit Court of Appeals case. So this meant filling out sponsorship forms during Christmas break. I mean, I was corresponding him, I think, on Christmas Eve. And I'm not sure if he's going to be able to make it today, but he certainly has my gratitude for, being an alum and going the extra distance for our students today. I really appreciate it. Finally, I need to mention the one and only Deb Leathers. Her unsung support has been essential to the success of the Amicus Project. And I've said this many times to her since we got started in 2013. Thank you, Deb. Now I will turn the meeting over to Sam Dennis and to her Amicus supervisor, who will chime in from time to time, Dean Julie K. Waterstone. Sam's going to share her screen and begin the presentation. You're on, Sam.
Well, good afternoon, everyone. As Professor Epstein said, my name is Sam Dennis, and then Professor Julie Waterstone with my faculty supervisor for the brief. And so we'll just jump right into it. I think Professor Epstein gave a really good intro, but this case focuses on the right to education. And so this is a Rhode Island case. It's based in Rhode Island, and it was originally the governor named Raimondo. And so it was a group of minors and their guardians who essentially were arguing that they were not receiving a sufficient civics education in order to prepare them for, their civic rights, such as voting, serving on juries, and really being able to understand the political system. And it started, at the federal district court in Rhode Island. And so there were two main arguments that they made in their brief. They were arguing both equal protection, and then they were also arguing a substantive due process right. And so there's just a quick summary facts of the case, as I gave before. It was really just based out of, I believe it was 11 minors and their families is how it originally started. And they just said that, again, that at the public school level, they were not receiving the tools that they needed. And so in the equal protection argument, they were arguing that the San Antonio v. Rodriguez case, and if you've had constitutional law yet at Southwestern, that case might sound familiar to you. But they were arguing again that Judge Smith, Judge Smith was the district court of Rhode Island. He was the judge who wrote the opinion initially for the case that we were partnering with. But he makes the argument in his opinion that in the Rodriguez case, the door was left open for claims of where there was either no education given or just the education being received was totally inadequate. So while that case kind of typically stands for there's no constitutional right to education, this judge once again recognized that that door was left open a crack in certain situations. And so again, with that case typically, stands for, in my constitutional class with Professor Miller, it was there to show us that there is no constitutional right to education, but as you'll see in a later slide in our brief, we really focus on that little crack that might have been left open and how it's applicable in our case and also in our brief. And then they also made their substantive due process argument. Basically, what they were arguing is that because education is so deeply rooted in American history, that it should be in the traditions of American history, that it sets a precedent that even though that it dictates that while education as a civic ideal is deeply rooted, as I mentioned before, there's still no right to civics education in the Constitution. And that's kind of how the judge, again, how he found on that point. He found that even though it is something deeply rooted, it kind of fails because there's still no constitutional right. So again, our brief is different in that we're arguing a federal right to education. And so going on to the next slide. Okay, great, it looks like it's working. Actually, no, did it pop up to the next slide where it starts at our argument? Okay.
Not yet.
All right.
While you're working on that, I'll just chime in. Judge Smith, the district court judge, wrote a beautiful opinion. I think it was like 50 pages long, really in depth, talking about how important education is and the role that it plays in society and why it needs to be one of those things that we value, but that there hasn't been an explicit acknowledgement that there is this right to education.
Yeah, it's when you read his opinion, I mean, he says he's filled with regret that he can't grant the relief requested. And it's also ironic because it's so learned and it cites to historical and classical sources. It really underscores just how important a good education is in order to make an argument, which I found ironic since, of course, he felt he couldn't grant that relief. And as I think Sam was just about to say, we have an answer for him, we believe, that would allow him to grant relief if you were given that opportunity again by the First Circuit. Sam?
Yes, and before I hop into that, I did want to express our interest specifically in joining this cause. And so now it should be on the slide that reads the Amicus Project. Okay, great. So it starts with the Children's Rights Clinic at Southwestern. So at in the Children's Rights Clinic, which I participated in this past fall, we advocate for students and their guardians to ensure that students with disabilities receive the educational resources and assistance and any services that they need in order to adequately access their education. And what allows us to do that is the Individuals with Disabilities Act, also known as the IDEA, and which really becomes the basis of our argument. And so what the IDEA stands for is it requires that public school systems and school districts provide a free and appropriate public education for all students with disabilities. And so that's referred to as FAPE, as you see on the slide there. So really in joining this action with our brief, we're seeking to establish that the court's recognition of a right to education for all, not just students with disabilities. So this would ensure that students with or without the label of having an educational disability will have the resources that they would need on an individual basis to ensure that they do have access to that free and appropriate public education. And so there we go. I think we should be able to actually move forward to the next slide. Slide number 4. Okay, so here we go, the basis of our argument. I'm sorry, I think it skipped a slide once again. Nope. Okay, there we go. Okay, so the IDEA represents the federal government's recognition of a right to education for all. That was the basis of our argument. And we argue this by showing the court that the language and the purpose of the IDEA itself demonstrate that the federal government has already acknowledged a right to education for all. For example, one purpose that was listed within the IDEA statutes itself is to ensure that children with disabilities have sufficient access to the public education system. But they do this in hopes of lessening the disparity of educational opportunities between those with disabilities versus those children without disabilities. However, they use the foundation, of course, of their enactment of the IDEA to be that there is a disparity between those with disabilities and those without. So that inequity between the two groups assumes that those without disabilities already have an equal right to education and already have a right to a free and appropriate public education. So since the IDEA guarantees, again, that free and appropriate education to those with disabilities, the Act is once again just assuming that that right already exists in those without the disabilities as well. So a specific section of the Act, section 1400 C7, it states that the federal government recognizes that it has a responsibility to provide equal education or educational opportunities for all individuals. And so that was one example of some of the language that we clung to in our arguments, showing that the court and the federal government, they have been considering the rights of education for all children in enacting legislation such as the IDEA. So they're already considering the fact that they believe that all children have this right to education while they're making these additional rights for subgroups such as children with disabilities. And so moving on to equal protection. And so we do also make an equal protection argument in our brief, but it is a little bit different than, of course, how the plaintiffs were making their argument in the initial case. And so we argue that the foundation, again, of the legislature's reasoning in acting the IDEA is that, either equal protection justifications. And so the fact that they took that into consideration is showing that there's already this existing right to education for those without disabilities as well. And one of the cases that we point to is Park versus Pennsylvania, which is a 1972 case. Where the court held that the state of Pennsylvania was required to provide children with a free and free public education, but tailored to their specific learning capacity. And in that quote from the case, it does not say just children with disabilities, but just children generally. And then another case that, and this looks good, so I can see that that transitioned well this time. But then in another case, a few years later, so a 1975 case, this is Ghost v. Lopez. And there the court held that an individual's education is a valid property right. And that a student has a legitimate entitlement to a public education, and that that education is protected by the due process clause. So we also bring in due process in our brief as well. And this was a Supreme Court decision. And so one of the Senate reports that I was able to find in doing my research gave a really beautiful quote. And again, this is a Senate report just showing some of the intent and the purpose behind the enactment of the IDEA and some of the conversations that were going on as it was being drafted. And there that quote says that the right to a free, appropriate public education is basic to equal opportunity and is vital to secure the future and prosperity of our people. And it goes on to say that it is contradictory to this philosophy when that right is not assured equally to all groups of people within the nation. So again, it's just showing that the IDEA is predicated on the fact that there is already an existence of a right to education for all. And in enacting the IDEA, what Congress was hoping to do is really just to make that fair and accessible to those with disabilities as well. So additionally, our brief also points to how minority children and children in low income areas and households are disproportionately impacted without the recognition of a right to education. We argue that those with less financial resources have a less opportunity to fight for educational services or resources that they may need on a personal level, because if they do not fall under one of the categories as a child with an educational disability, then they really don't have any legal leg to stand on as a student with a disability would. So with less financial resources and income, they're less equipped to battle and to receive the resources that they may need as well. And then lastly, we talk about subsequent legislation to the IDEA, such as the No Child Left Behind Act, which really just stands for, it's almost creating, defining the scope of the right to education in a way. That particular act guarantees that it's trying to close the gap between the achievement gap, essentially. And so it does that by stating that all students are entitled to a high quality education. It doesn't go on to define high quality, but again, that statement is something that we cling on to because it is describing the right to education for all students and that it's supposed to be a high quality education. And then there are also, we briefly mentioned in the brief, state compulsory attendance laws. So there, almost every state across the nation has some sort of attendance law that's actually holding the guardian of the student accountable for ensuring that the child goes to school. So it's pointing to not only the importance of education in our nation, but it's actually giving legal repercussions for not engaging in the educational system that we do have. And then I also want to share how our brief is different from the other amicus briefs that were submitted. So there were 9 additional briefs submitted to the First Circuit. And in going through all 9 of them, I noticed that maybe 1 mentioned the IDEA at all, but a good 7 of the 9 briefs are very similar to the core case and the actual appellant's briefs, and that they're arguing that there exists a right to specifically a civics education. And they do that, by arguing either disparity in terms of impact across different minority groups. I saw a couple briefs that did that. Or they just argue again that this is so deeply rooted in our American history that it must be recognized. But again, they are focusing very much on the civics education. So our brief is a little bit more bold and goes a different route in arguing that there really does exist already a federal right to education that has been acknowledged and has been intentionally recognized by our federal government. So we believe that this is a really important angle for our brief, and it was the right move for us to take, because if we're trying to do is help the appellants in the McKee case, if we're trying to help them receive an outcome in their favor, we believe that you can't really find that there is a right to a civics education without first the acknowledgement of a right to education more generally, because that right to a civics education really falls within a right to education. And I think that that is pretty much the gist that I was wanting to share with everyone today. But Professor Waterstone, did you want to add to anything on that?
The only additional piece that I think you outlined that beautifully and kind of in talking about where we're coming from, but I think it's almost been taken for granted that a right to education exists, and the federal government, the Supreme Court has never come out and explicitly acknowledged that right. And my fear is without any kind of acknowledgement that those rights can be taken away, they can be eliminated, and there's no repercussion. And I think about young people, for example, who are incarcerated. You know, if there's not a specific right to education, then what happens when they're sent away? You know, if they're locked up and they come back into society and they're not given that educational benefit, then they're not able to meaningfully contribute. And that's one of the reasons that I think it's so important for us to actually recognize that right to education, so that we have that baseline, that when young people are out and trying to succeed, we hold that value very dear to us as Americans, and one of those that I believe should be one of the fundamental values. And I think it's important that we have a federally established right so that it cannot be taken away ad hoc.
Right.
Absolutely. I just would like to, add that this was, a big discussion that the three of us had, of course, as this brief was being prepared. But, the federal government presupposes this right already. I mean, imagine without this right, a state could just decide we're going to go out of the education business. We're not going to have a public school system. That would undermine the premise of IDEA and a number of other acts, as we pointed out in the brief. I mean, would it be better if it were expressly acknowledged? Absolutely, but it's already there. I do think that the court would not stand for a state to say we're not going to provide a public school education at all anymore. And if they did that, they wouldn't be able to comply, I think, with these federal acts. They would be breaking federal law. So maybe that's a de facto right. So that's the gist, I think, of what Sam was trying to argue in this brief. And I think, Sam, you argued it very, very well. Any other points you want to make, Sam, in response to that?
No, just in response to that, I was going to say yes. In doing, research on the history of rights to education, it's interesting because it is never expressly recognized. If anything, it's expressly denied in certain situations. But the courts, writing those opinions are always very careful to not deny a right to education just very broadly. They always leave some sort of door open, or they have a very narrow opinion to the situation at hand. And so I agree with Professor Waterstone and Professor Epstein that that's why we saw, I guess, our opening in this brief is that there has been at least some implicit recognition and definitely an intent by our federal government to recognize a federal right to education.
And to add, in terms of the specific strategic importance of our brief, that became clear to us when Sam and Julie and I had a Zoom call with the lead counsel for the petitioners, for the children, because when we discussed this idea for the brief, with Julie taking the lead on this, it was clear that the counsel for the petitioner appellants hadn't thought of this at all. It didn't even occur to the counsel that this would be an argument that could be made. He then said he might make some brief mention of it, and he did make brief mention of it, I believe, in his brief, but very brief. And it was clear that that was going to be our job, and specifically Sam's job, to make these arguments. And I think that's important. It really underscores the role that I've envisioned for the Amicus Project in these cases, which is it's not to just repeat arguments that are made by party counsel, or to weigh in with what is often referred to as a vanity brief, where you're basically making a position so that you can get an organization's name into the case. it's really about trying to come up with an argument that's strategically important precisely because it's not being made by party counsel or by other amici. And because of that, it will educate and inform the bench. And that's where things stand now. Sam, I don't know if you want to give them an update on where the case is right now, but I'll just say before you do that, the brief is with the judges and their clerks. I mean, they have it in their possession and they are reviewing it, right now. But you can fill them in, Sam, if you want, on where things stand and where you think things may be heading.
I was going to say, I know that when we discussed this earlier this week, Professor Epstein, we know that the appellees have asked for additional time to submit their briefs. And so that should be happening within the next couple of weeks. So at most, we'll probably have an update this summer. I would say is probably the earliest, so June or July. But I am excited to see how it goes. I do little updates on Bloomberg to see who else has submitted. So it's nice that you are able to track the progress also after you submit the brief too. And then just from a student's perspective in working for the Amicus Project, if anyone's interested in doing that, I would highly encourage you to send an application. I joined maybe a more untraditional way because I was already in the clinic with Professor Waterstone, and then the timing worked out very well. But, I worked on it over Christmas break, which was the first challenge, I would say, but it was so well worth it. I don't have anything like this on my law school resume, and I probably won't be able to do anything like this for a number of years already into practice. So it's a really great experience, and I would encourage anyone who's considering it to go ahead and apply.
Okay, I just realized that I didn't unshare your screen, so now you can see her perhaps more fully. And that's good because now is the time for Q&A. So if you have questions, we would love, and I know Sam would love to entertain questions. It's hard to believe, Sam, right? In just those, over Christmas break and into January and a little bit of February, you pretty quickly became an expert, right, on the right to education. Do you feel like you're an expert on these issues now?
I definitely feel like I could talk to pretty much anyone about it and have a lot to say. So, yes.
All right, so if people do have questions for our newly minted expert and this very specific and important issue, this would be the time to ask. Beth Caldwell.
Hi, thank you so much for sharing your experience, Sam, and for taking this on. I have a couple of years ago, I got pulled into writing an amicus brief and had no idea how much work it was. So I can say that you tackled a huge project. I learned that through personal experience, and I think it's amazing you did so as a law student. So my question is kind of theoretical, or I don't know, big picture question. This has come up in some immigration law issues. There was a big case, Plyler v. Doe, which you may have encountered, where the question was, could a state deprive undocumented children of their education? And the Supreme Court said, no, you can't do that. But they declined to rule because of a fundamental right to education and instead ruled on equal protection grounds. And it sounds like you trace this same kind of reasoning in a bunch of other cases. And so I guess my question is, do you have any thoughts about why the Supreme Court seems to have been so reticent to just recognize what seems to be this de facto right to education?
And so I summarized that case, and I can't remember if the summary actually made it into the brief or not, but that was one of the cases that I researched and looked at for this brief as well. And so I think that you're correct in that a lot of the other cases, they find any other basis for making their ruling and for writing their opinion other than the right to education. And at least theoretically, I think that's because of the way that the San Antonio v. Rodriguez opinion was written. And we're even taught in our constitutional law class, at least with Professor Miller, it shows that the door is left open. But so I was hanging on to that idea at the start of my research and writing for the brief, but then I went and read the case again, and I was struggling to find that language that showed that the door was left open at first, because I thought that maybe initially it was pretty explicit, or that they really said that we're leaving this issue open for a later time. but it's actually pretty implicit in the writing. And it just says that essentially that under these circumstances, we found that there is no infringement on the right to education, is how the Rodriguez case kind of ends. And so I think that because that case is the landmark case and the writing is so vague when it comes to the right to education, my thoughts are that, you know, subsequent courts have been scared to really say, you know, explicitly that there is a right to education and then make a further ruling on the right. If that hopefully answers your question.
Yes, definitely. Thank you.
Yeah, and in Plyler and in these other cases, they don't, the court never says, of course, that there isn't a right to education. They're just not finding that there is. And I think that's an important distinction to make. Other questions for Sam Dennis and Julie Waterstone? Lauren Krug. Lauren.
Hi, so assuming that your brief achieves a favorable result for your party, how would the fundamental right to an education be impacted in the world of COVID if we have a lockdown and we have such a technology gap, particularly with underprivileged children? Where do you foresee possible solutions, especially in light of the current infrastructure bill?
I think that's a really great question. And I have thoughts on it just from my work with the clinic, actually. But so I don't know if Professor Waterstone, if you have anything that you want to add now, or if you want.
Why don't you start, and I have thoughts as well, but I'll jump in as after you speak.
Okay, I was going to say, I'm sure she has a lot to say on that too. But my thought, Lauren, is that so with the clinic right now, even with those students with disabilities who are protected by the IDEA, it's become a great struggle to make sure that they are getting the resources that they are entitled to by their IEP, which is their individual education plan. And so they're afforded certain resources by the plan, but what we've been doing in the clinic, or at least remotely, is it's a struggle to make sure that they're also getting those same resources at home that help them to achieve their educational goals. And so what I would think would happen is that if there is a recognition more expressly of a right to education for all children, that in the world of COVID, I think that it's just defining the scope is what I think would have to be next. And I think that that would be the next struggle, is they would say, well, they are getting an education, they're able to log on to Zoom, they're at home, and as long as they're sitting in their chair and whatnot, they're receiving their right and their access to education. So I think that the next struggle would be really defining the right to education and defining the scope and the quality. We have, like I mentioned before, there's the one case that says high quality, but it doesn't describe what that means. And so I do think that that would just bring up further discussion. So this is really just the first step.
And to expand a little bit, I mean, one of the things that we've seen in COVID is that most school districts, I'd say large majority, are providing technology to individuals that do not have access to technology. Now, that might just be a laptop, which is great, but then what happens, and we've seen this obviously with our clients, but what happens for those who live in more rural areas or who don't have access to internet, you know, or their internet's unstable? How are they getting access to that same education? And some utility companies have been great in providing hotspots, but we saw them for short periods of time. So it might have been a 4-month period. So I think, to me, the question that we're going to be facing when students start to come back is kind of piggybacking off of that No Child Left Behind idea, is how do we make up for the time that students have lost out on the education? And one argument is that all students have lost out on their education. So we can't really, you know, say, well, some are getting it and some aren't. But I think we do have an inequality situation here. I think we have, you'll see, particularly, let's just say with the private schools, those are going back. So the kids that have means, you know, they can put in all the PPE, all of the extra safety measures to go back to school. And for example, LAUSD, which serves a predominantly lower income population, they're not necessarily going back, or when they do, they're talking about not having the same level of instruction. So I think one of the hurdles we're going to have is how do we remedy that? There's clear ways in the IDEA to remedy. They have a provision for compensatory education, which is basically like a tutoring, but that's for kids with disabilities. What about all of our other children? So I would really love to see something where maybe we allow for in-person summer school for those students who are struggling. And you don't have to have an IEP or be a student with a disability to access that. Currently you do, but maybe we need to rethink how we're delivering that education, or rethink offering additional supports for struggling students, because I think there's going to be this whole period of reintegration, not just in academic learning, but also the social emotional piece as students go back. So I think, Lauren, it's a fantastic question. I think something that we're going to be grappling with for quite some time.
I have a follow-up question, if that's okay.
Sure, that's fine.
So if we're going to have potentially, hopefully, more quality education being provided, and that the fundamental right, or at least federal right to an education being provided, obviously we're going to need more teachers. There has been sort of a bit of an exodus in COVID with teachers. So what do you think the higher education, or I guess the impact would be on higher education learning geared towards professional educators?
So higher education, like beyond high school, is what you're asking, pretty much.
Beyond
right?
high school, like for a training program for more teachers to provide higher quality education. Because if the fundamental right to an education exists, or federal right, excuse me, to education exists, there's a demand now that needs to be filled of educators.
Sure.
So that's what I'm looking at, or what I'm curious about.
Yeah, that's interesting. I mean, I initially, when I was offered the opportunity to work on this project, I did try to think, from both the legislature's perspective, the teacher's perspective, the parents' perspective, just like, how do I feel about the situation generally? But I would say that that's kind of the extent of how much we considered the teachers in writing the brief. Right now, I think our primary goal was just access to education for all students, and doing so by declaring that there is this federal right to education that needs to be recognized, and has been, is our argument by the government. And so I think that, yes, if there's a right to education, officially established and recognized, then the training teachers and making sure that teachers are up to par for that right, to help children receive their right to education, I think is a logical step of the process. But when I think of that, again, I kind of go back to my thought is the scope, and I just practically, when you have people trying to battle this out on both sides, I think that because it's so vague right now, all that we have to rely on are these other statutes and these acts that specifically lay out rules for education for subgroups. And so that's like the IDEA that Professor Waterstone was mentioning a couple of moments ago, where it really does lay out what it means to have a free and appropriate public education for a student with a disability. And so I think that having to make comparisons, between what those students are getting and what students without disabilities are getting would probably be the first step. And then looking at any regulations, dictating teacher qualifications and the teacher's education and training as well. But then with higher education, I think it's a little bit different, because a lot of what we see in the IDEA are children in like high school and younger, and that's who's protected by the act. And so I think that when you're talking about higher education, that's interesting. And I don't know if maybe the fact that a lot of times that's voluntary maybe would affect it. You choose to go into higher education. I don't know if that would be a different point that would be made, but I think it's interesting, but I don't really have an answer for that.
I actually was thinking about your question a little bit differently, Lauren. I was thinking about it from the lens of how do we encourage more individuals to go into teaching, and how do we incentivize them? And I guess, one start is, if there is this federal right to an education, to me that places a societal value on education that we don't necessarily explicitly state. I think, all of us who are either in law school, thinking about law school, teach at a law school, obviously value education, right? Or in undergrad, for example, you're thinking about higher education. So there's a value there, but that's not universal. And I think to the extent that we could create something that is more universal in our country, that would elevate at least the baseline. And then you layer on top of that things like the No Child Left Behind Act and other compulsory education laws. We hopefully, the idea would be we have a higher standard. Now, that needs to filter into, I think, teacher salaries and teacher training, and thinking about kind of this moment we're in time more broadly. I think we have an opportunity to really elevate teacher training in terms of social emotional teaching, capacity for understanding different cultures, backgrounds, ethnicities, and bringing that into the classroom. And I think that would go a long way. So I think there's a lot that can be done, but I think you have to start with at least the recognition that all kids deserve an education, and further, all kids deserve a quality education.
In Professor
There's
Waterstone's,
also I'm sorry, Sam, go ahead.
I was going to say Professor Waterstone's comment also reminded me of it wasn't a training, but a seminar that I went to last semester, Lauren, by the Jumpstart program, where they were having these conversations in how to kind of better incentivize the teachers, especially those who are having to teach during COVID and remotely, to keep being creative with their students and coming up with new ideas and just helping to further motivate the teachers. So those conversations are out there. It's definitely an important piece of the puzzle.
Yeah, and all I was going to say, Lauren, is, you know, that's the next step in the inquiry. I mean, we're at the threshold question: is there a right? And our argument, of course, Sam's brief says there is. It's been established, and that may be at great cost. I mean, there may be a lot of ramifications of the recognition of that right. It might not only be, you know, staffing and salaries and infrastructure, may also be arguments over curriculum, you know, and textbooks. You know, there could be qualitative and, you know, substantive and economic debates over how this right to education might be realized. But that's not, of course, anything we had to take on in this brief, thankfully. I mean, it might be a future case if the First Circuit is persuaded that indeed such a right exists. Sam, you want something to add? I want to add to that too?
Oh, that was it.
That's good. So Shara Darden, you have been waiting quite patiently. Shara?
Yeah, thank you. Congratulations, Sam, on doing this, taking this on and completing it. Seems like an amazing project. I'm a 1L, so my question will not be very informed. So I'll say that first, and then also that I just come across the term amicus brief in one of my other classes and had to look it up in my dictionary, and then saw this presentation. So it all jives now. It's all coming together what this is for me. But my question is about the fact that the courts haven't recognized a right to education. Do you think that, you talked a lot about scope, and do you think that is because it opens the door to have to offer free and appropriate education? To what end? You know, I know there's a debate about, you know, free higher education to a certain point and et cetera. Do you think that it opens that up, or can a right be granted in such a narrow scope such that it only covers kids? Because I hear you say all kids deserve quality education. So how do we define kids?
Yeah, I think that first of all, your question's plenty informed. But I think that in part it is that you, like we were talking about with Lauren's questions, there are a lot of potential expenses that come along, and that could create a lot more responsibility for the government, that, you know, they have to decide to what extent they want to take that on and be responsible for it and pay for it. But I also think that in doing my research, you know, when the Rodriguez case was decided, the San Antonio v. Rodriguez, the one that I said kind of left the door open for finding this right, in that opinion, they did not want to find, or they first looked to see, is there an explicit right to education within the Constitution? And they found that there was not. So, our Constitution, and you'll learn all of this next year, does enumerate certain rights, and right to education is not one of them. And part of that does come down to interpretation of the Constitution, because some would argue that the right to education may fall within a liberty right. And so that's, to an extent, another route we could have gone, I think. But then the case also goes on to look at whether or not there is an implicit right to education within the Constitution. And they said for the purposes of their case, not really, but we're just saying that for our time being and for the facts of this case, that the situation in the state is not, it's not violating, the Constitution, any constitutional right that may exist. So without getting into standards like strict scrutiny or anything, that was a problem with the case as well. And so going back to your original question, I think that they're so hesitant to find that right because at the time, the court was using, it seems like, more of a textual interpretation of the Constitution, which is that right it's not in the papers, it does not exist there. And then I think the rest of it is they were too scared to declare a right because it was not written in the Constitution, because then they would have to probably go on to define the scope of the right. But that's my thought. And I don't know if anyone else has something to add.
Just in thinking about your question with regards to the use of our term kids and who qualifies as a child, I'll just put out there that the IDEA provides for their right from 0 to 20 or through the 21st birthday. So when a child turns 22 or an individual, because at that point you're not considered a child, then you're no longer eligible. But I think even within that 0 to 21, it's still thought of as K through 12 education. You're not looking at it from a higher education standpoint. So when I think about this right to education, I really focused on the right of K through 12. And I think that's what the No Child Left Behind Act focuses on. That's what our compulsory state attendance laws focus on. So that's when I was thinking and we were writing about kids, that's where I went. And would argue that that's how the right should be applied as well.
Great question. Byron Steyer, Professor Steyer.
Hello. Yeah, thanks for this. It's very interesting. I'm learning a lot about higher education. Not something I normally write or think about, although I teach obviously in it, but and education constitutional issues. But my question is actually about the kind of litigation setting. And since we're using first names, Michael, good to see you, even virtually, miss in person very much. But the litigation aspect, Michael, that you were raising about the role of the amicus in supporting the litigants and how the amicus can bring something new to the table and not just be repeating, I think is a really interesting point. We did an amicus in practice and we had the same kind of thinking. How can we add, strategically big picture, something more theoretical that the litigant might not really want to be focusing on? But I'm wondering, and this is a question not just for this case, but in cases generally in the Amicus Project, how do you navigate that? Is it just sort of one conversation with the litigants about how do you see us doing something can help you? Does the Amicus Project have its own kind of agenda that may not necessarily be tied to what the litigants want? It's an interesting thing. And then also, do you feel like you need to do follow-up with them where they get to comment on your brief or you weigh in again? It's just an interesting dynamic between those two sides, the amicus and the litigants in the case. And thanks again for all this.
So that's a great question, Byron. And this is something I gave a lot of thought to at the time when I created the Amicus Project. And we're fiercely independent of the parties. And we're that way for a couple of reasons. One, when we take briefs up into the Supreme Court, we need to very specifically say that we are independent. We're not taking support from parties, and that usually refers to financial support. But I think it's important that we establish ourselves as our own pro bono program. That's separate. So we don't necessarily have a an agenda in the sense of a political agenda, but we do have what I would call a litigation agenda or case agenda, in the sense that it's really important that we establish early on, at the time the student is coming into the practicum, and this is often a conversation I might have with a prospective supervisor, and then also with that student at the beginning of the process, as to what I refer to as the reason for being, the raison d'etre of the brief. Why are we writing this brief? What's important here? And we usually have this conversation, almost always we have this conversation before we have any interaction with counsel. And there have been some cases where we haven't even had interaction with counsel other than to request their permission to file a brief. And we've never been denied that permission from the parties we support and the parties that we may be opposing. But that's an important part of our procedural posture, if you will, coming into a case. We need to have a reason for filing the brief. In this case, this was really, a discussion that developed between Dean Waterstone and me, and then almost immediately with Sam when she came on board to take this. That this was not something that was at all in any of the any of the paper trail for this case. Nobody was giving this any thought, and we confirmed that when we actually had an early Zoom call with the lead counsel for the students, as I mentioned earlier. Usually we find that when they're, the counsel for the parties that we are writing in support, that we propose to write in support of, they're usually extremely eager to bring us on board, because of course we're on their side and they want the more the merrier. But I look at that intake meeting, if you will, as an opportunity to listen, not an opportunity generally to talk about what we have in mind. And the reason for that is sometimes if we just sit there and say, well, here's what we're going to do, it may just become, the council may decide, well, this is a big part of what's going to be our brief. We want to make that argument. Now, a real savvy counsel won't necessarily want to do that, because they'll realize they don't need to use up the valuable real estate in their appellate brief to make an argument that we're going to be making for them. But you can never really be so sure. And so we try to keep the specifics pretty close to our chest. Now, that said, we were very excited about this particular angle, and we did talk a little bit about it in the intro meeting, and it was fine. The appellant's brief did briefly mention, but just in passing, the issue without any of the nuance and any of the specificity that Sam was able to put into her brief. But that's the short answer, or the shorter answer to your question, Byron, is yeah, we try to be independent, and we try to make sure that we're writing this brief for a specific reason, that our goal is to inform and educate the bench by making arguments that others are not making, whether it's other parties or either other amici. And in the 8 years that we've been doing the Amicus Project, every one of our briefs have met that criteria. Thank you. It's a great question. Julie, do you want to add something to that from your perspective, or Sam?
I thought you covered it well.
Okay.
Agreed.
No, thank you.
Thank you. Great.
Okay. I see Lauren has another follow-up, or a new question, perhaps, a short one. Yes.
It's actually a follow-up to the question you just responded to. Not knowing when you had your initial discussion with the litigants, but with the change in the Supreme Court makeup, especially now that Justice Barrett is sitting on the bench and she tends to follow more of the originalist interpretation of the Constitution, my question's more for Sam with, did your approach really focus on the bench's makeup right now, or did it ever change? Did your litigation agenda change because of the makeup?
Now,
Just
before
curious.
Sam answers that, Lauren, you need to know that this is in the First Circuit Court of Appeals. So this is not going to be a Supreme Court issue. And the other thing you also have to know about appellate practice, that you generally don't know who your bench is going to be, because it's a 3-judge panel. So Sam, you can answer with specific to whether you gave any thought to the First Circuit panel that you thought you might be arguing in front of.
Not really, because politics are kind of so heightened in our society right now. I did just look and see kind of how, where the state stands and whatnot, but not really. We had a good idea of what we wanted to argue, and I felt really confident in where we were going with the brief, so it didn't alter the brief.
So great. We have time for one more question, and that question is going to be from the student who first brought this case to our attention, from the University of Southern California, Erica Knoll. Erica.
Thank you. Yes, my question mostly for Sam. Reading the defendant's initial brief filed in the district court, it seemed to me that a lot of their argument hinges on the subjectivity of what defines a quality education. In thinking about this case, that is something that I personally found challenging to grapple with. How does the brief tackle that in the context of FAPE, of particularly appropriate education? Does it set any parameters?
Sure. So just to make sure I understand your question, and also it's very nice to meet you, but in making sure I understand, does our brief, the one that we submitted, does it talk about how, subjectivity as far as the quality of education, and do we suggest any sort of scope? Is that what you're asking?
That is exactly what I'm asking.
Okay, so the answer is really no. We talk about it. I talk about the high quality quote only because in that case, the Goss v. Lopez, it's just it's more proof that the federal government has recognized a right to education generally. And it was just kind of like a ha-ha in the brief, just say, not just did they recognize the right, but they also said it should be high quality. But we don't go into any discussion as to what quality means or the scope of it, just because that's going further beyond. That's, again, kind of part of the next step. Right now, we are just hoping that the court will affirmatively recognize that the federal government as a whole has instituted a right to education through the enactment of all of these additional statutes and acts. Hopefully that answers your question.
The only thing I would add is, honestly, the appropriate part of FAPE is what is most litigated under IDEA, is what constitutes appropriate. So I think with regard to this right to education, if you tack on high quality education, that's going to be the piece that's litigated. Are we actually providing high quality?
So on that note, we're going to come to the end of our time together today, and I just want to conclude by, throwing out big props to you, Sam. Big kudos. Yes, the hands are up. I can see the digital hands, and it's deserved. I mean, you blew this out of the park. You hit it out of the park. It was, tremendous how much work you did in a short period of time, because as you know, the Amicus Project, it's the one class at Southwestern. It doesn't work by semesters, it works by court calendar. And that means a lot of work over a relatively short period of time, but you just did superlative work and highly motivated. I couldn't be more proud of you, Sam. So thank you. This is a point of pride for Southwestern Law School. It's been a real thrill for me to direct the Amicus Project and direct a whole host of students like Sam, who have really done professional quality work as a law student. So if you are interested in learning more about the Amicus Project, feel free to email Amicus Project, all one word, at swlaw.edu. And I'm happy to talk with you more about how the Amicus Project works. But for now, thank you very much for listening. Sam, also, it's Sam Dennis 18, right? S Dennis 18 at swlaw.edu if you want to reach out to Sam directly with more questions. I don't know, maybe it's one of these things where once you write the brief, you're never going to let these issues go, right? You're still eager to engage them, right?
Yes, and definitely please feel free to reach out if anyone has any questions. And thank you again to Professor Waterstone and Professor Epstein for giving me the opportunity to work on this project. And it was really, it was something unlike anything I've ever done before, and I learned a lot. So thank you.
Well, it's our pleasure, and thanks to Julie Waterstone also for being there for every step of the way. So again, Sam, beautifully done, great work. Thank you.
Yes.
Take care, everybody. Bye.